Hello and welcome to this video. Today we're having a chat with Patrick Smith, who is the Principal and Senior Solicitor at O'Brien Smith Lawyers here in Horsham. Patrick is a local guy with a young family here, and we really welcome Patrick to provide his expertise on general estate planning. And so thanks Patrick, thank you for coming, we really appreciate your time.
Oh, I'm glad to be here. Thanks for having me.
No worries at all. Now, I thought we'd best start with just general estate planning, and obviously the key foundation for any estate plan is having a will.
That's right.
And a lot of Australians at this point in time don't have a will for whatever reason, so there's probably a huge lack of understanding of why you should have a will. So that's really my first question: why should people have a will?
Yeah, that's exactly right, Rob. It's something that's really important to make sure that people's assets go to who they want them to go to. So if they don't have a will in place, it actually goes to legislation, so what the government's mandated how it should be distributed. So for example, it'll say if someone's died with no partner and kids, this should happen. If someone dies with no partner, no kids and no parents, this should happen. Now, sometimes that can make a result where someone that you don't want to receive the benefit of your assets receives them. So for example, you might have had a falling out with a sibling, and that sibling receives a large chunk of your estate. So it's something that's really important. The other key thing as well is it makes it much easier for the people left behind to know what you wanted and to be comfortable that your wishes are being fulfilled.
Right, and if you die without a will, can that make the process of getting the money to the right people, obviously not the deceased person's choice, can that make it a more expensive thing to do?
Exactly right. It can be more difficult and it can result in a more complex court application if the will is there to be followed. So definitely something that's really important, and it's actually probably important to note as well, the cost of actually putting a will in place is often cheaper than the cost of fixing up a mistake afterwards.
Right, and I suppose that cost, I often hear people talk about, I've been to the local post office and I've got a will kit, and that might be a $25 expense. The difference between a will kit and what a professional solicitor like yourself would do, where's the key differences there, Patrick?
Yeah, so that's actually been an absolute nightmare, the will kit. So I've had quite a few of those cases where I've had to go to the court and you've got to convince the court that it was an actual proper will, because there's issues always, well, quite often with how they were executed. So it might be that they weren't witnessed correctly. It might be that there was a residuary clause missing, meaning that it doesn't actually say who should receive the final assets. And so we've had cases where it's actually cost thousands to rectify that will kit, whereas if this has gone and spent a couple $100 with the solicitor, we wouldn't have had that problem at all.
Yep.
So it can really save a lot of money just by doing it right to start with.
Getting an understanding of what assets go into someone's estate, I think people get quite confused about what's in and what's not in, and people think, well, if I own, the house or the asset within the trust, they just assume that that's their asset. And whilst it's their effort and their money that's gone into to buy or build these assets up over time, they're not always within someone's estate.
That's exactly right. So family trust, because it's held in that trust arrangement, doesn't form part of someone's personal estate. So really all it is forming part of a personal estate is things like your personal home that's in your name, or an investment property that's in your personal name, not in a trust.
Yes.
Vehicles, savings, investments, anything that's in your personal name. But as soon as it's in a company or a trust, or even your superannuation, that doesn't automatically form part of your estate.
Right. And even as simple as a husband and wife having a joint account. Joint accounts.
Exactly right. So rather than you thinking, oh, my half will go to whoever I wish, no, because it's held jointly, it'll go to the partner. And the same with the husband and wife owning the house. If they own in joint names rather than tenants in common, it'll just go to the survivor. It won't be dealt with under your will.
Right. Okay, so a joint account, the last standing rules and the sole survivor.
Yep.
But just explain tenants in common for us, because that's obviously joint assets, and then there's tenants in common. The distinction between the two.
So when you purchase a property with your partner or with anyone, you can have the option. Do you want to make it as tenants in common, which means that you do have a share in that property that you can leave in your will.
Right.
Alternatively, if you choose to put it as joint tenants, then it will just go to the survivor. So you can't actually bequeath it in your will.
Right. And what is your preference in terms of just a simple home ownership, which is most people's scenario.
Quite often it's just husband and wife, they're comfortable with it going to survivor. So I think that actually works quite well because it saves some paperwork. Really, it's just going from one to the other, not having to worry about what the will says. It's just straightforward, automatically transferring to a survivor.
Right. You touched on superannuation before, and along with our home, superannuation is becoming a very large asset now, with the contribution rate for employers going from 9.5% to 10% now. So that's becoming an increasing pool of assets.
Sure.
So superannuation is not doesn't form part of the estate. How should people handle superannuation assets?
Okay, so most superannuation accounts, and it does vary between some funds, but most will actually offer the option of putting a binding death nomination in place. And what that does is it actually binds the trustee of the superannuation to pay it out as you wish. So for example, you could say, I'd like it to go to my wife.
Yes.
And the trustee would have to follow that. The things to remember with binding death nomination, quite often they expire after 3 years. So it's something to keep on top of, because you don't want to find that, well, I haven't done it in 3 years, and so it's up to the trustee again. The other option is a non-binding, one of the other options is a non-binding death nomination. That actually allows the trustee some discretion. So generally we say it's preferable to put in place a binding death nomination. In terms of who you leave it to, there are some important considerations between how the taxation legislation deals with it and how superannuation legislation deals with it. So, for example, lots of clients I see start by thinking, well, maybe I should just leave it to my children. And if they're adult children and out doing their own thing, that can actually be not ideal. So whilst they're able to receive it under the superannuation legislation, under the taxation legislation, they're actually going to be having a lot of their benefit lost in tax.
Yeah.
So generally in that situation, if you have got a spouse, the spouse is preferable. Another option is, if you do want to have it dealt with under your will, is to put a binding death nomination in favour of your legal personal representative. Which just means it goes to your estate and then can be dealt with under your will.
Yeah.
Now this is quite complex, so I think this is one where you really want to talk to your solicitor about in detail and make sure you do get it right.
Absolutely. In our working with our clients, just to, I suppose, build on that, the tax consequences to non-financial dependents, it's 17% tax when paid to they can be a beneficiary from a superannuation law, but tax law, it's going to cost you 70% on the taxable component of the fund.
Yeah.
And the taxable component's made up of salary sacrifice and employer contributions, which for most people that's a large bulk of their funds.
Yeah.
So it's quite a serious issue. When it comes to binding death nominations, they do have non-lapsing ones now.
That's right.
So there's a lot more flexibility there, where you don't have to go back and revisit as well. So that's fantastic. Patrick, with high net worth clients considering testamentary trust, can you give us an overview of the benefits of a testamentary trust?
Yeah, I mean, there's a few, and it does depend on what people's circumstances are, but quite often if you've got, like you said, the high net worth clients where they've got substantial assets behind them, they can actually then put in place trust to their children, creating the opportunity for their children to distribute income to their children, so the client's grandchildren, which can result in great tax savings. It's also great for asset protection in a lot of circumstances. So if you've got someone, for example, who you're worried about, say, a child's partner, and you don't think that they should really have access to your inheritance given to your child, for example, that can be structured to protect those assets. So it does depend a bit on the circumstances, but quite often there will be significant savings for your children if you're leaving an inheritance.
Yeah, fantastic. And when the option to establish a testamentary trust happens within the will itself, and it's only an option, Patrick, is that correct?
It depends on how it's drafted, but that's how we draft it. So it will be an option, and normally we say they have 6 months to determine if they want to actually put that in place. They can speak to their own accountant and decide if that is an option they want to take, but generally that is something that will be done because the tax savings are there.
Right, yeah, fantastic. And at sort of what levels of money do you think it's appropriate? So a client that has their home, so 2 children, their home and investment assets of $500,000, so we're expecting $250,000 to go to each child. do you feel as though that would be appropriate for assets of those levels?
We generally have a $1 million threshold. That's where we say it really makes sense to actually put it in place, because there are costs to running a testamentary trust as well as the extra accounting costs, but they are pretty minor compared to the benefits once you get over that $1 million threshold.
Right, fantastic. So generally high net wealth, so $1 million and there's 4 children, you'd probably say we won't bother there, but $1 million going to one beneficiary, it would be more appropriate.
Yeah, definitely.
Yes, yeah. Fantastic. All right, well, while we're going on, obviously wills, there's one key person that plays apart from the person dying, there's the executor, the person that's in charge of administering. So can you, I suppose, give us an overview of the role an executor plays?
Yeah, sure. So executor is a crucial role, and it's going to be someone that you feel that you trust to take care not just of your legal affairs, but also your personal and financial affairs. So you want someone that does have some basic level of financial understanding to start with. What they need to do is actually put in place what you've got in your will into action. So for example, if you're leaving specific assets to a specific beneficiary, say you've got a piece of jewellery that's been handed down for your family, you want that to go to someone in particular, that executor needs to be able to be trusted to make sure that that asset does go to that person. They also need to be able to instruct the solicitor or deal with the solicitor to administer assets, bring assets into the estate and then distribute them to the beneficiaries. And it's also a good thing to keep in mind is how the executors get along as well. Sometimes you will have children that you want to put in place as executors who don't fight. That can work, but it's something to think about. If there's another option, maybe you have one child first, and then if they can't act, the other one's a backup, for example, that might be more suitable. So there's a lot of considerations to make around executor, and it's also good to speak with who you're thinking of putting in place to make sure that they're comfortable with that appointment as well.
Right. And as a general rule, obviously adult children is ideal to have there, but
yep.
not your brother or sister that's 5 or 10 years older than yourself.
I guess it depends on the age of the client. So if they're in their early 30s or something like that and their older siblings only in their 40s, that's probably okay.
Yep.
But if you're getting on past that, you've got to start thinking about, well, what's the likelihood of them predeceasing me? And if that's quite high, then maybe you think of someone else.
And in addition to age and relationship, you need a certain ability and sort of administration skills to administer a estate, or is that something that if you're working with a solicitor that these people are often guided?
Exactly right. It's not as scary as it would seem. I mean, as I said, you want someone that has a basic level of financial understanding so that they can make sure that even the solicitor is doing what they should do, but the solicitor will take control of it and deal with the assets on your behalf. So a lot of the difficulty of the role, it can be taken away by the solicitor, but you still want to make sure that that person does have a basic level of understanding to make sure everything's done correctly.
Fantastic. Just moving off topic a little bit, Patrick, where we're living in a farming community and there's often disputes around farming assets and obviously wills can be contested. I was of the opinion, and I could be wrong, where if a will is contested, the estate pays for that. Was that rule changed in recent times where if someone contests a will, it's at their own costs, and so it makes people think a lot harder about whether they contest a will or not?
It does depend on the circumstances. So it can be either way. It does depend on what the actual trial comes down to. So if the claimant was successful and they actually succeeded in contesting the will, normally the estate would pay their costs. If the estate was successful, it's more likely that they would have to pay their own costs. But quite often with those contesting the will, they will settle before they go to trial anyway. So it will actually be at a mediation or and part of the negotiation between the lawyers that a result's received, and that will actually determine how costs are paid.
Yeah, fantastic. Very good. Thanks very much, Patrick.
No worries, Rob.
Cheers.
Thanks.